Hi, everyone. So today we're going to talk about the judicial branch and the nomination and selection of judges. So let's go ahead and get started. So as always, make sure to follow Think Fiveable on Twitter, Instagram, and YouTube. We are on all of these social media platforms, and we have AP review sessions for all of these subjects. So it would be super important for you guys to make sure that you follow this and so that you can really get all of the updates. Okay, so just a little bit about myself. My name is Akhilesh Shivramakrishnan, and I'm a junior from North Carolina. I love politics, and I took AP Government as a sophomore, and I got a 5 on the exam. So I'm super excited to help people learn more about AP Government, what like everything about politics, getting interested in politics, and I'm excited to be streaming for Fiveable this year. Okay, so let's get going. So just a little bit about our AP Gov team. We have streams every Tuesday and Thursday. So these are some of the streams that are coming up. October the 28th at 8:30 p.m. we have a weekly current events and election update. On the 29th at 7 p.m. we have a review session on the First and Second Amendment. At 8 p.m. on that same day, the 29th, we have a session on monetary policy and the Federal Reserve. And then on Halloween at 7, I'm hosting a session on the rights of the accused, amendments 4 through 7. So please, we would love for you to join, and let's get started with our content. So first, we're going to start with some College Board standards. And I like to start out each review session with this because it really helps with setting a goal of what we want to understand by the end of the session. The other thing that we want to do is go ahead and start talking about the American judicial system. So this stream specifically is talking about selection and nomination of federal judges. But I just want to start out with an overview of the American judicial system so that we can get accustomed to everything that the judicial system has in it, and then we can move on to the selection. We're also going to talk a little bit about something called senatorial courtesy, and then we're going to end with some multiple choice review, as well as some tips on free responses. So just about the College Board standards that align with this, there's 4 main topics: the judicial branch, the legitimacy of the judicial branch, the court in action, and checks on the judicial branch. The topic of nomination and selection of judges really mostly deals with that last topic, the checks on the judicial branch, and we'll kind of learn a little bit more about that as we go on. Okay, so some questions for thought. So if you guys could just answer these into the chat. What are the 3 branches of government? How can you summarize each of their roles in 2 words? And what do you already know about the judicial branch? So if you guys could just put what you know in the chat, and that would be great. Okay, so I'll wait a few minutes and then I'll just keep going. But the 3 branches of government are the executive branch, the legislative branch, and the judicial branch. So each of these have really important roles, and the interactions between the branches of government is actually one of the unit titles in AP Government and is one of the central themes to the course. Summarizing each of their roles in 2 words. So this is something that we kind of emphasized even from like civics that you might have taken like your freshman year. So the executive branch or the legislative branch makes the laws, the executive branch enforces the laws, and the judicial branch interprets the laws. So just knowing those 2 words that you can associate with each branch can really go a long way because you can apply those 2 words to almost any situation to determine what role or what powers each branch has. And then we're going to learn a lot more about the judicial branch in this stream. So hopefully you have some background knowledge. So the American judicial system is something called an adversarial system of justice. So an adversarial system of justice is used in common law countries, and it's basically when two parties with opposing opinions on the same situation are working toward the same truth. So they want to get to the truth, and they're attempting to pass a judgment accordingly. So they're working towards the same goal, but they're on opposite sides. So this normally happens as arbitration before an impartial person. So with the judicial system, that would be a judge or a jury. And the judge or the jury is what determines the truth and at the end passes that judgment. Another thing about the American judicial system that is unique is that we have two basic kinds of cases. We have criminal law cases and civil law cases. Criminal law cases are basically something that you would think of when you would say a crime. So it's government charges for an individual because they violated a specific law or they hurt someone or infringed upon someone's rights. This could be an offense that would be harmful to another individual or harmful to society as a whole. So criminal law is kind of what you think of when you think of someone going to court for a crime. On the other hand, a civil law dispute is basically when it's between two parties, and that's kind of an example that helps illustrate that is family law. So with family law, there was no crime committed necessarily, but for example, like divorce proceedings would fall under the civil law category. The other thing with the American judicial system is that we have both state and federal courts. So there are differences in the cases that they handle. For example, federal courts generally deal with cases that deal with federal courts deal with cases that deal with constitutionality, laws and treaties, disputes between states, anything that's on a much larger scale that could involve more than something happening in just one specific state. On the other hand, the state courts mostly determine everything else and are responsible for everything else. So small criminal offenses, civil trials, etc., are normally all happen in state court. The exception with criminal cases is that if someone commits a federal crime, then the case starts out in federal court. So there are differences between both civil and criminal law and state and federal court. So those are basically the two kind of key differences that you want to think about. And there's a graphic organizer on the right. You want to screenshot it or maybe look at it later, but that has a really good overview about the differences between criminal and civil law. Okay, so there's a lot of key terms that you'll hear when we talk about the judicial branch. So the judicial branch, in my opinion, is probably the most complicated branch of government because although its role is so broad, it has so many different functions and there are so many different levels. So I just want to kind of go over a few key terms that you'll probably hear at some point in terms of a court case. So you have a plaintiff. A plaintiff is a person who brings a legal action against another person. So they're the person that is basically pressing charges. Another term that you'll hear associated with plaintiff is standing to sue. That's basically saying that the plaintiff has to have a substantial interest in the case, and they have to have sustained a they have to have already sustained a danger or be in immediate danger. So they must have gone through some kind of pain or it has to substantially affect them. So a lot of times you can't, if it's not really affecting you or if it can't really be resolved through judicial action, it's not ethical or it really can't happen where a plaintiff sues. Additionally, we have something called class action lawsuits. A class action lawsuit is a lawsuit brought by an individual or a group of people on behalf of all of those that are similarly situated. So an example would be, I believe I heard of a case where like a union, they brought, or like a union, I think a person that represented the union, they brought a case in favor of all a group of women that had faced sexual assault. So this lawsuit was brought about by one individual on behalf of a large group of people that experienced a similar situation from in relation to the same defendant. So that kind of leads us into the next word, which is defendant. The defendant is someone that is accused of something. So in a court case, it's normally the plaintiff versus the defendant. Another key term that we have is NAACP. that you might hear. The NAACP is a national association for the advancement of colored people. And basically, these are interest groups that are trying to find people that they can go get behind so that they can win cases. So the ACLU, which is the American Civil Liberties Union, and the NAACP are always trying to find litigants or people that need help with their cases, and their cases relate to civil rights and civil liberties. Another key term that I know will likely appear on your AP exam or is something that you can use in your FRQs and make your vocab sound really good is Amicus Curiae briefs. So Amicus Curiae is a Latin term that means friend of the court, and it refers to interested groups or individuals that are not a part of the judicial branch. So they're not justices, they're not judges, but they might file briefs, or they basically what they do is they send stuff to the court in order to support one side. So it's like outside influences on the court. So this is a way in which the public can check the judicial branch, although the judges are not required at all to, they're not obligated at all to actually take into account what the amicus curiae briefs say. It's a way in which the public, companies, generally like famous people or other politicians can try and influence the judgment or the result of a case. So a famous example is the President Obama filed an amicus curiae brief supporting same-sex marriage when that case was in the Supreme Court. So Obama is not a part of the judicial branch, but in order to influence the judicial branch, he wrote to the Supreme Court about why he believed that same-sex marriage should be legalized. Okay, so we kind of just went through some of the key terms, and now we're going to go to the structure of the federal court system. So the federal court system is quite complicated, but it is easy once you kind of get the hang of it and you're used to all the different processes that go on. The lowest level is the district court. So there are 91 district courts in the country, and cases are decided by a jury. Then the next level is the Court of Appeals. At the Court of Appeals, the cases are decided by a panel of 3 judges, and there are 12 courts of appeals across the United States. So you have one for each region. So kind of like the Southeast has one, the Northwest has one. They kind of split it up evenly. And then the highest court in the land is the Supreme Court. And on the Supreme Court, there are 9 justices. There's 8 justices and 1 chief justice, and their ruling is final. So a unique thing about the American judicial system is that you can appeal your case. So if you lose your case at the district court, you can appeal to the Court of Appeals, and then again, you can appeal to the Supreme Court. The Supreme Court is kind of like the final level, so you can't appeal beyond that. The other thing that you might want to write down or jot down is that the United States has what's called a dual system or a dual court system. So not only are there federal courts, there is also state courts. I'm not going to talk a lot about state courts because the structure kind of varies from state to state, but states generally have regional courts, they have trial courts, they have superior courts or Supreme Courts, and each state has a different way in which those feed into the federal court system. Generally, though, if a case starts in the federal court system, that means that a federal crime has been committed. Okay, next slide. So we're going to talk a little bit in specific about district courts. So, apologize, can't see that for a minute. Okay, so district courts, there are 91 of them, and they have what's called original jurisdiction. Original jurisdiction basically means that cases can't start here. So the district court has the authority to hear cases first. There's at least one in each state, in DC and in Puerto Rico, and they do not hear appeals. So what we'll see is that appeals courts have appellate jurisdiction, whereas these district courts, they have original jurisdiction because they hear the cases first. So the district courts aren't hearing appeals, rather they're hearing stuff for the first time. And these are the only federal courts that actually have juries. So as you go up after this, there are no juries. For example, at the Supreme Court, there's only justices, the 9 judges. And when you get to the courts of appeal, there are a panel of 3 judges. There are no juries past this level, so that's something that you might want to write down. The other thing is that the district courts have between 2 and 28 judges. They sit on varying size panels, and that's something that again varies by the district court that we're talking about. The jurisdiction extends to, like I said, federal crimes, civil suits under federal law, and bankruptcy proceedings. So something in common that goes with these is that they are all federal offenses, or maybe federal offenses, or can affect the country as a whole rather than one specific state. So bankruptcy proceedings, especially of large companies, start out in district courts, and civil suits under federal law, they're kind of going with the criminal suits under federal law. So these are, again, are two different types of law. And those cases can both start at district court. So does anyone have any questions so far about what we've covered? Okay, let's keep going. So a little bit more about the district courts. 98% of criminal cases in the United States are heard in state and local courts and not in federal courts. So that's something that's important to remember. A lot of times when we hear about court cases, we hear mostly about the Supreme Court. However, it's very, very, very unlikely that cases even make it up all the way to the Supreme Court. 98% again of criminal cases, and I apologize for that typo, are heard in state and local courts. So they don't even make it to the federal level. This is mainly because of the types of offenses that are committed, as well as the magnitude of these issues. Another thing, like I said, they must have committed a federal crime. Some other key terms that you might want to know are U.S. attorneys are nominated by the president and confirmed by the Senate. So these represent the U.S. government in civil cases at the district court. So what we said before was that the government can be a party in the case, even at the district court level. So you can have an individual filing a suit against the government. So in that case, the government also needs somebody to represent them. So the person that represents them is the U.S. attorney that is based in that district. The next thing, so we're kind of going to transition. If you lose the case, what do you do? So you appeal to the next level of the court, which is the courts of appeal. So the courts of appeal are also quite unique. They're divided into 11 judicial circuits, plus there's one that is based in DC, and there's one called the Federal Circuit. The Federal Circuit, what that is, if you ever hear it, it's not going to be something that you will probably need to know, but it might be good to reference somewhere, is that it was established in 1982, and it's to hear appeals in specialized cases. So these are more like talking about patents or claims against the United States in relation to trade or other international type of disputes. So that Federal Circuit is also something that is present, along with the DC Circuit and the 11 other regionals. You then, each of these courts of appeals serves at least 2 states and has between 6 to 28 permanent circuit judgeships. However, normally when they actually make decisions, they do that in panels of 3. The other thing that is super important here is that the courts of appeal are not deciding whether a person is guilty or not guilty. What they're looking at is correcting errors of procedure and law that occurred in previous proceedings. So they're looking to see, was there something wrong done in the procedure of the trial? Or was a person not allowed to represent themselves? Or anything that really deals not with the actual situation at hand and whether they were guilty or not guilty, but a little bit more about the constitutionality and the procedural aspect of what actually happened. So there are also, these are appellate courts. So I know we talked about this in the on the previous slide with original jurisdiction, but these courts have appellate jurisdiction, which means that they have the ability to hear appeals. On the other hand, what we talked about before, the district courts, they only have the power of original jurisdiction, so we are not able to, they're not able to hear appeals. Like I said, there's no trials of guilty or not guilty, and there's no testimony here either. So that's the other big part. There's no actual testimony that occurs within this trial. Okay. Lastly, the other one of the most important courts is the Supreme Court. The Supreme Court is the highest court in the land. It is probably the court that you hear about the most. It has both original and appellate jurisdiction. The Supreme Court has original jurisdiction for a select few cases, such as disputes between two states, things like that. However, most of its decisions are based on its appellate jurisdiction. Basically, in order to get a case up to the Supreme Court, you need to file a writ of certiorari. A writ of certiorari is basically a request to the Supreme Court for them to hear your argument. Basically, what happens is that barely any of these cases are accepted. So a big thing with the Supreme Court is that they control their own agenda. And something that we'll look at is that because it is unlikely to get your case all the way up, because you have to, like, the case has to be really significant or have the ability to impact future cases. So it generally, the cases that are accepted have something to do with constitutionality, rights like the carrying out of the trial that might have gone against one of a criminal law case that does not really have wider significance or more national significance is not going to make it all the way to the Supreme Court as what's on the side. The justices actually get to control their own agenda. So the justices get to decide what cases to hear. There are 9 justices, 8 associates, and 1 chief. Currently, the Chief Justice is John Roberts, and he was appointed by George W. Bush. We're going to talk a little bit more about who the justices are and how they're appointed in just a little bit. So, kind of a little checkpoint question here. If you would like to answer this in the chat, please feel free to do so. So, if you can name the 3 stages of the federal court system that we talked about, what an amicus curiae brief is, and an example of a civil versus a criminal case. So, I'll wait a few seconds, and then we'll go over these and proceed to more about nominations. All right, so we're going to talk, we're going to go over these. The 3 stages of the federal court system are: at the top is the Supreme Court, right after that come the courts of appeal, and then after that comes the district courts. An amicus curiae brief is something that I would really recommend you familiarize yourself with for the AP exam. A lot of times it appears on multiple choice questions as either a correct or a wrong response. So if it's a correct response, that will benefit you. If it's a wrong response, you'll be able to eliminate it if you know exactly what it means. An amicus curiae brief is amicus curiae. That term means friends of the court, and it's basically when the public tries to influence court decisions. An example of this is Obama doing this with the case that involved same-sex marriage. An example of a civil and a criminal case. A civil case could be a dispute between people, such as divorce, and a criminal case would be an actual crime that was committed. That would come under the spectrum of criminal law. Those are the answers, and we'll get going. So, judicial selection. So, Supreme Court judges especially serve as part of a president's legacy. So that is why a lot of times those Supreme Court judges have the ability to impact so many future generations, and that's a huge part of the presidency, and probably one of the roles that the president most not enjoys, but takes the most pride in, as his decision has the ability to impact the country for maybe 40, 50, 60 years in the future. These Supreme Court justices are guaranteed to serve for life under good behavior. The reason for that is that we want them to be insulated from political pressure. We don't want them to have to always be thinking about if they would have a job in the future and job security. Therefore, we make sure that they're guaranteed to serve for life. Another thing that I believe is in this PowerPoint is that Congress cannot change a justice's or judge's salary after they have been appointed. So at that point, again, they're not worrying more about like if they're going to be paid a different amount, etc. They're completely insulated from political pressures, or that is a goal. so that they are not influenced by Congress or the presidency. They are supposed to be and try to be the most independent branch. So we kind of talked about why we want life terms to insulate them from political pressure. The only way in which federal judges can be removed from office is by conviction of impeachment. And this has rarely happened with federal judges, although there are some cases. It is not something that happens frequently. Let's keep going. So judicial selection. Sorry, I can't see the slide. There we go. So federal judges serve for life, and Congress cannot reduce their salaries, something we just talked about. This again insulates them from political pressures, and that's something that is super important for the judicial branch. It's arguably the most powerful branch because of judicial review. What judicial review means is that the Supreme Court has the ability to review the decisions of the executive and legislative branch. So they can decide if something that the president or Congress does is constitutional or unconstitutional. And something that we would want to know is who nominates and who confirms federal judges. So federal judges are nominated by the President of the United States. That is based on the advice and consent of his staff, of his cabinet, of anyone really that he wants to involve. And it is confirmed by the Senate. So that's something, again, that you'll kind of see as a theme. Most confirmations happen with the Senate. So that's one of the roles that the Senate plays, and that is very significant. All right, so now we're going to talk a little bit about judicial nomination and selection, specifically when dealing with the lower courts. So lower court nominations. So there's something called senatorial courtesy. So this is not something that I personally saw on the AP exam or was emphasized in my class, but I definitely think that it's important to know, and it can play a big role in your FRQs, especially if you have one about checks and balances. So senatorial courtesy is basically an unwritten tradition where nominations for any federal judicial posts are not confirmed if they're opposed by the senior senator from a state. So if the senator, so like let's say the president nominates someone from my state of North Carolina. If the senior senator from North Carolina says that he doesn't agree with the nomination, the president really is not supposed to appoint them. Although they're not obligated to abide by this tradition, in general, that is a role that the senators have played as a check on the president. In this case, in some cases, even the senators from the states have put forth decisions to the president and he chooses. A lot of times, however, you will find that this term senatorial courtesy does appear on the AP exam if it is an answer choice for multiple choice. And again, a lot of these terms are going to do that, and it really benefits you to know the vocabulary so that you can eliminate the wrong answer choices on the AP exam. So, like I said, the presidents normally check with the senators before making decisions because the problem is if they put out the nomination to the public and then the senator comes forward and says, no, he doesn't approve of this person. Now they've kind of wasted all of that time in which another person could have been nominated that the senator agrees with. And the next thing that kind of we're going to talk about with lower court nominations is that there's a complete background check. So just like at school, when there's volunteers that come in from outside places that need to be checked to make sure that they're safe and they're safe to be around our students, the exact same thing happens with court nomination. So the names are submitted to the Department of Justice and the Federal Bureau of Investigation, or the FBI. The reason why they do this is they have to carry out a complete competency and background check. You don't really want someone that you know has not abided by the law before be the one that's deciding the law for other people now. So definitely these background checks happen before the nominations are actually put out to the public. Competency tests also happen to make sure that these people are qualified to serve as a federal judge, which is an important role. Something that we want to remember with this is that federal judges can serve for life. So if a wrong decision is made, or if they are truly not competent, there's really nothing that anyone can do once they've accepted the judicial post or been confirmed by the Senate, because they can't be impeached unless it's because of quote unquote bad behavior. Therefore, these background checks are super important. The nominee is basically chosen from those that pass the screening process, and increasing polarization has affected the nominations, and not only with the Court of Appeals, but with really all federal courts. An example of the Supreme Court where this took a ton of time was in President Obama's last year of office. So Justice Antonin Scalia passed away probably just about a year before President Obama left office. At that point, the Senate was controlled by Republicans, and their argument was that they would not really even give Merrick Garland, the person that President Obama nominated to fill the post, a vote, because there was going to be a new president that was taking office in just about a year. So the reason why this generated a lot of controversy was because it was President Obama's role as commander in chief and leader of the executive branch to nominate someone to the federal court, and therefore people felt that the legislative branch should also fulfill their role by giving his nominee a vote. However, they did not, because at that point there was a possibility that a Republican could become president, and because that happened, eventually Merrick Garland's nomination died. So he was nominated to the Supreme Court, but he was never confirmed. Eventually, President Trump nominated Justice Neil Gorsuch, and he was eventually confirmed to the Supreme Court. So increasing polarization between parties and a lot of politics is what has influenced these nominations. However, really the judicial branch is supposed to be very independent from politics. On the other hand, when you have presidents that are nominating federal judges, they're generally going to appoint judges that agree with their ideology. So you generally have Democrats that appoint liberal-minded judges, and Republicans nominate conservative-minded judges. So that's really not going to change. However, this increased polarization has definitely affected nomination and selection. Can't see the slide again. Sorry. Right, like I said, the time for confirmation has increased dramatically, and this is really because of differing political views. So the next thing we're going to talk about is specifically the Supreme Court. The Supreme Court is very unique in that it has a lot of components that none of the other courts have. Legacy is a huge part of this. The Supreme Court is the highest court in the land. So when you have presidents that nominate justices, this is really the only part of their presidential career that is going to stick with the American political system for a long period of time. This is a huge influence that the presidents have over the judicial branch. So they're going to be really interested in appointing justices really as soon as anyone steps down from the Supreme Court or anyone passes away, etc. The main reason why, again, this is a legacy is because the justices stay for life. However, they're not required to nominate any, or they may not get the opportunity to nominate any. So, for example, Jimmy Carter, he did not have the opportunity to nominate any Supreme Court justices because all the justices during his presidency were living and none of them stepped down. So he did not have the opportunity. So it's not like it's a requirement. However, I think in most presidencies they have nominated federal judges, or I think all of them have nominated federal judges, but I know Reagan has nominated a Supreme Court justice, as has H.W. Bush, Bill Clinton, W. Bush, and Obama, and now Trump. So in general, there is a time at during their presidency that they get the opportunity. However, it is not a requirement. So there are several constraints that could be placed, especially in lower court nominations. However, at the Supreme Court, the president faces much less constraint. So senatorial courtesy, which is what we talked about with the lower courts, does not play as huge of a factor with the higher court and the Supreme Court. So they have much fewer constraints on who they should nominate. A lot of times the people that they nominate is based on aid from their White House staff, the Attorney General, the Department of Justice. All of these agencies and people kind of play a role in deciding who the nominee is, because the president really doesn't face any opposition from the legislative branch when making the nomination, as opposed to senatorial courtesy with lower courts. Justices that are already on the court can influence who they want to be their future colleague. However, the president, again, has no obligation to take their advice. And something that we mentioned before with the senatorial courtesy, it doesn't really apply to, that should say, Supreme Court nominations. However, that hasn't stopped senators from trying to exercise it. So a lot of times, if a senator truly believes that a Supreme Court justice is not fit and they are from their state, they will express that. However, the problem with this is that the Supreme Court and being on the Supreme Court carries a lot of prestige. So the senators know that if they say, oh, well, no, this person isn't fit to be on the Supreme Court, the president is only going to nominate someone from a different state. It's unlikely that the president will nominate someone from that same state where he could possibly face opposition again. And because the Supreme Court carries so much prestige, and that's a big positive for the state, generally senatorial courtesy is not something that plays a huge role at this point with the Supreme Court nominations. Another term that you might hear is blue slip. A blue slip is basically a slip on which the senators from the nominee state give their opinion on. So it's kind of a term that isn't used as much anymore, and I can almost guarantee that you won't see that on your AP exam. However, it is something that kind of connects back to the senatorial courtesy where their opinions are still valued. Something that we've kind of grown with in the 21st century is that is a concept of a litmus test. So like I discussed before, Republican presidents tend to nominate conservative judges, Democrats tend to appoint liberals. So what people worry about is that there's almost like a litmus test kind of thing of ideological purity that's used to select judges. And really it should be based on qualification and not political beliefs. So the argument with this is that people that may be more qualified but are of a slightly different ideology or political ideology are not nominated to higher courts because the president doesn't agree with their standpoint on issues. However, at this point, there's really nothing that we can do about that. That's just what's going to happen. Republican presidents are going to nominate conservative judges, and Democratic presidents are going to nominate liberal judges, and that's kind of just been the pattern and is a power of the president. I'm not sure why I can't move my mouse. Oh, there it is. Okay, so this is kind of like a helpful graphic organizer that might help you see exactly what the selection of federal judges looks like. I'm going to post this with a replay if anyone wants to see it, and I'll post a slideshow in the call to action section. However, this is a really good summary from Ballotpedia about the selection of federal judges that will prove useful. Oh, we just talked about that. So next thing we're going to talk about is kind of an overview of the current Supreme Court. I'm just going to kind of go through all of these justices. First, I'm not able to point on the screen with I can try, but I'm not able to point on the screen to which justice is which, but I'm just going to kind of go over who each justice is and who they were appointed by and when they started their term. So the first justice, the one that's been serving the longest, is Clarence Thomas. He's been serving since 1991. He was appointed by George H.W. Bush, and he's a conservative. Ruth Bader Ginsburg was appointed to or nominated to the Supreme Court in 1993 by President Bill Clinton, and she's a liberal, or generally liberal-minded. Ruth Bader Ginsburg is only the second woman to serve on the Supreme Court, so she has also been known to be really very almost like strict, and she's very knowledgeable about her style and about her knowledge on the judicial system and law. The next person is Stephen Breyer. He was nominated by President Clinton again, and is liberally minded. He was appointed in 1994. The next person is was appointed by George W. Bush and is actually the Chief Justice. So the person in the center here is John Roberts, and he is the Chief Justice and is conservative minded. He started serving on the court in 2005. Samuel Alito was also appointed by Bush, and he's conservative. He was appointed in 2006. And then the other two women that appear in this picture were both nominated by President Obama. Sonia Sotomayor was the first Hispanic woman to serve on the Supreme Court. She started her term in 2009, and Elena Kagan was also appointed by Obama, and she started her term in 2010. Then finally, we have our two justices that were appointed by President Trump, and are the junior justices. Neil Gorsuch was appointed. Neil Gorsuch is the one on the far left, standing. He was appointed by President Trump in 2017, and Brett Kavanaugh, who was recently confirmed in 2018, who's on the far right, was nominated also by President Trump. As far right, as in the picture, so not like belief, but yeah. So we're going to talk a little bit, not solely about their position on this picture, but also their views in terms of the political spectrum. So I came across this chart and thought it was really interesting as to everything that it kind of talked about. So if you look on this spectrum, you see how liberal and conservative these people are. It kind of includes all 9 justices. So if you look at this, Sotomayor and Ruth Bader Ginsburg are the most liberal on the court. Clarence Thomas and Brett Kavanaugh are the most conservative on the court. And you have John Roberts, who is closer to the middle section. A kind of cool thing with John Roberts is that recently he has been aligning a lot more with the liberal candidates, and that has kind of caused some confusion, especially with the people that, both with the people in Congress that are Republicans, because generally before he had been always aligning with the conservatives. However, in recent times, he has kind of made decisions and supported decisions with the liberal wing of the court. But I thought this was just a really cool representation of the ideological scores, is what it calls it, of each of the justices on the court. All right, so another thing that I kind of wanted to address is checks and balances. So checks and balances is a key topic in AP Government, and you will 100% see this on both your multiple choice and your free response. A main check and balance that the legislative branch has on the judicial branch is that they get to confirm these justices and federal judges. So if Congress, or specifically the Senate, does not agree with the president, they can reject the nomination. So really, it's a check on both the executive branch and the judicial branch. Additionally, you have a check on the other two branches by the judicial branch, which is judicial review, where they can review any decision made by Congress or the president in terms of its constitutionality. And now we're going to kind of transition. We're almost finished. We're going to transition into some checkpoint questions. So these are some AP Government multiple choice questions that are very similar to the ones that you will see on your exam. I'm just going to put the question up and give you guys a chance to read it, and then we will discuss the answer. Okay, so this question asks, which of the following best explains how the president can limit the court's power by appointing a new Supreme Court justice? A, by changing the jurisdiction of the court. B, by decreasing the likelihood of the Supreme Court hearing a case. C, by choosing justices who change the ideological leanings of the court. And D, by increasing the total number of justices on the court, reducing the impact of the existing justices. So we're going to kind of go through each answer choice. So A says changing the jurisdiction of the court. So one thing that we know is what we talked about at the beginning with our summaries of each of the roles of the branches. Changing the jurisdiction of the court would be deal with having to make a new law. So really changing the jurisdiction even if possible, would be something that only the legislative branch can do. So that wouldn't explain really how the president can limit the court's power. So we know it's not A. B, by decreasing the likelihood of the Supreme Court hearing a case. We know based on the question that putting a justice on the court isn't going to dramatically change the likelihood of the Supreme Court hearing a case because there are 9 justices that make the decision. So yes, it could have an impact on maybe certain types of cases that the new justice would want to hear. However, it's probably not the most important. So we're going to keep B, but we know that it might not be the strongest answer. C, by choosing justices who change the ideological leanings of the court. So we know that presidents choose judges that often align with their political beliefs. So we know that Democrats generally tend to appoint liberal-minded judges and Republicans tend to appoint conservative-minded judges. So based on this, we can kind of infer that this answer is pretty strong, but we're going to go ahead and read answer choice D. So D says that by increasing the total number of justices on the court, it reduces the impact of the existing justices. So again, like we did with A, changing the number of justices on the court is really something that would fall under the role of Congress. So it wouldn't make sense that the president would limit the court's power by increasing the total number of justices because it's not something the president can do. So in this case, between B and C, which we know both have correct elements to it, C is definitely the much stronger answer. So the answer is C. All right, so the other thing that I kind of wanted to go over are some hints for free response questions. So free response questions are kind of a source of struggle for many students, especially with the redesigned AP exam. The redesigned AP exam has a lot of different types, well, not a lot of different types, 4 different types of free response questions that you will need to know how to structure. So kind of dealing with what we talked about today, I'm going to talk about the Supreme Court FRQ. So there's 4 things that the Supreme Court FRQ expects. They are identifying a common constitutional concept in 2 cases, describing relevant facts from a required case, explaining similarities or differences between the holdings in required and non-required cases, and explaining the interaction between case and the prompted concept. So what's kind of going to be presented to you with the Supreme Court FRQ is you are going to be given, you have a list, hopefully your AP government teacher has already taught you this or told you about this. You have a list of 15 cases, landmark cases that you are required to memorize. So you need to know these cases in and out, and you need to be familiar with the plaintiffs, defendants, why it was decided, its background, and what the final decision was. In addition, you should basically be able to write a good summary about what happened in the case and relate it to a key concept in AP government. So there are a lot of videos that you can find both within Fileable and online that deal with all of these landmark Supreme Court cases that you will need to know. So what they'll give you is they'll give you a short little blurb about a case that you've never heard of. And this case will be in some way related to one of the required cases. So they'll give you case A, and then they'll say related to Brown versus Board of Education. So they will prompt you with a specific concept that they want you to talk about. So they might say identify what concept is common between case A and Brown versus Board of Education. Then you would need to write a response about why these 2 cases are similar or why they were decided differently. Then what you need to do is kind of almost write an essay about the differences between these 2 cases and why maybe a different decision happened or why the same kind of decision held. Then you need to explain the interaction between the case and the concept that is prompted. So this is something that we'll continue to practice in Fileable with writing for response questions. To study, what I would recommend is going on a watching Fileable streams, of course, but going on websites and just reading more about the cases. Don't wait until the beginning of May to look at these cases because you definitely need to know them in and out. So pacing yourself by doing like 1 or 2 cases every week and kind of reviewing them throughout as you get to May for the AP exam would be definitely beneficial. If anyone has questions, you can ask them now. Almost done. Okay, so our just a little reminder again about our upcoming streams. So we have an upcoming stream on the 28th, next Monday, which is a weekly current events and election update. So this is something that we do every Monday, kind of talk about what's going on in the country that's politically motivated and about the 2020 election. Then on Tuesday at 7, Ms. Johnston is going to talk about the First and Second Amendments. At 8 p.m. also on Tuesday, Mr. May is going to talk about monetary policy and the Federal Reserve. And then on Halloween at 7 p.m., I'm going to talk about the rights of the accused, Amendments 4 through 7. So please join us for all of these streams and make sure to follow us at Think Fiveable on Twitter, Instagram, and YouTube. And that's it. So if anyone has any questions, I'll stick around. But if not, thank you and have a good evening. All right. Thank you.